Yeah. All right. I might have to shorten that intro a bit. I've seen it on other channels, maybe 20 seconds or something, but I kind of like it. So I don't know. And then Megan Fox, she can have if she can have a 7-minute intro, why can't I have a 2-minute intro? Hello, folks. Good to have you here on, at least over here, on this beautiful fall day. It is 10 a.m. Eastern Time. Earlier, if you're further west in the United States, it's much later if you're in Korea. And here it is 4 p.m. All right, good to have you all here. Good to have you over at Rumble. Hello, Ambrosia. Hello, Anima Rampier. And folks, I'm actually live now on Twitch. I have 0 followers. I have no idea if it actually will work, if it will draw anybody there. If you have a Twitch account, my name over there is Mixed Auto. So I have no idea if it's going to work. No clue whatsoever. My apologies. But I have 1 viewer over at Rumble. Over at Twitch all of a sudden. That's nice. Hello, Twitch viewer. Good to have you here. Good to have you here. And over at YouTube, my main thing. Hello, Happy Annie. Hello, Rhonda Hall. M169. Wim is lurking. I'm okay with lurking as long as you at least once every 10 minutes puts something in the chat. Remember, folks, this channel was a bit dormant during my trip to the United States. So I really, really need you to hit the thumbs up. And that goes for Rumble and Twitch as well. And just because, hey, I kind of need you viewers. I kind of need to have you viewers here. And so, yeah. Despite everything, and hey, Rhonda Hall stepped over on Twitch. Hey, Rhonda. Good to have you here. Good to have you here. She's now over at Twitch. Yay! I have my first follower is Rhonda Hall on Twitch. Yeah. Now, as you all know, running this show is not free. It's free for you to watch me. It's not free for me to do all the things. I am roughly at between roughly $350 per month in expenses. So please hit the like button. Please subscribe if you haven't yet. Please check my videos so I can get the ad revenue and push through the YouTube, Rumble, and Twitch glass ceiling. So I just wanted to say that. I still haven't figured out how to get Rumble chats over here at StreamYard. I know it can be done. I have to ask Steve because he has done it and I don't know how it's done. All right, folks. Yeah. Aaron Spencer. For you who don't know, Mr. Spencer is charged with ending the life of his daughter's groomer, rapist, kidnapper, Michael Fosler. Michael Fosler, we now know, had his first victim in the 1980s. And there's nothing that says he then was dormant until he did the things he did to Aaron Spencer's daughter. So, again, I urge any of Michael Fosler's victims, please come forward. Your story is important. And other victims need to know they are not alone. Michael Fosler is no longer here to hurt you. His parents also gone since long. The Fosler family cannot hurt you. Now, the cops who protected him back in the 1980s, 1990s, probably isn't around either. So they can't hurt you. So please come forward. Now, this is what's one of the things that's really bugging me about this case is that I have been actively trying to find information about Michael Fosler. I'm good at finding information. Not your, I mean, you start out with the normal things like, okay, ask Google, ask DuckDuckGo, just search for it. Then go into, okay, where did he live? Okay, search the public thingies for information. Michael Fosler might not have, I mean, if not for, we know that he was employed as law enforcement in Indiana and then started a trucking company, and the houses he have owned, he might not have existed because there's literally nothing. He is scrubbed from internet. Everybody leaves tracks. Everybody. And when you find absolutely nothing, especially a known groomer, rapist, and it's gone, it's not there, somebody chose to remove it. The information is so scarce that in itself tells me somebody actively removed it. Hopefully, through the Aaron Spencer case, they can find out more through means I cannot. His attorneys are probably scouring everywhere themselves for information about Michael Fosler. Hopefully they get more than I can, because I'm somewhat limited, because I have to go on the VPN, I have to create accounts and then search for charges, traffic ticket. I don't know if you know about trucking companies. I know a bunch of my viewers are truckers. I'm very happy that you are here. Trucking companies and there are fees, and sometimes the employees screw up. So there are, hey, you need to pay this fee. There's nothing. You tell me, truckers out there, have you ever worked for a trucking company that is completely clean? Completely clean. That almost never happens unless it's associated with law enforcement. You think about that for a second. Why Michael Fosler is so completely erased from public domain, to the degree you found his house. Yeah, of course. We know he gave it to his daughter weeks before he kidnapped Aaron Spencer's daughter. But before that, I mean, his trucking company, yeah, we have a registry of it. Pay taxes. But apparently, in the 20 odd years he had this trucking company, not one citation. Not one. I cannot find a single one. Now, of course, I cannot exclude that other people might find it because they have other resources I do not have. But usually when I look for these things, I find them. And here, nothing. So the big question about Michael Fosler is, who has been protecting him for 50 years? Who has protected him? All right. Now, that's the bad news. Here's some good news. Aaron Spencer is now he's charged with. Now, I do not believe he can be convicted because of the circumstances, unless he is prohibited by the judge to bring forward the circumstances. Michael Fosler, the charges against Michael Fosler, and everything. But if the jury finds out the actual circumstances, I do not think there's a jury in United States that would convict Aaron Spencer due to self-defense laws. And in Arkansas, you have self-defense of self and others. And the situation, his daughter was kidnapped by the person who groomed and raped her. Over 40 counts was charged against Michael Fosler. So no, I do not think that. And let me bring this up. Where is it? Some really good news. Michael Fosler is running for sheriff in the same county who tries to put him away from life for life. From ABC on your side, Lonoke County man Aaron Spencer, accused of ending another man he discovered in a car with his 40-year-old daughter in 2024, is now announcing his run for Lonoke County Sheriff. He's running for sheriff. Now, this here, seriously, could you not have extended this with some facts about Michael Fosler? A Lonoke County man, Aaron Spencer, accused of ending another man he discovered in a car with his 14-year-old daughter in 2024. First of all, it's not in a car. In Michael Fosler's truck. And what? Let's see if they actually mentions Michael Fosler. But Aaron says, this campaign isn't about me. It's about every parent, every neighbor, every family who deserves to feel safe in their homes and safe in their community. It's about restoring trust where neighbors know law enforcement is on their side and families know that they will not be left alone in a moment of need. Together we can build a safer and stronger Lonoke County for every family. Spencer made this announcement Friday evening on his campaign's Facebook page, launching his bid for Lonoke County Sheriff just 1 year after being charged in a fatal shooting. And let's listen to it.
Hello, Lone Oak. My name is Aaron Spencer. Many of you know my story. I'm the father who acted to protect his daughter when the system failed. I'm also a husband, a combat veteran of the 82nd Airborne Division, a contractor, and a farmer. And through my own fight for justice, I have seen firsthand the failures in law enforcement and in our circuit court. And I refuse to stand by while others face these same failures. That's why I'm announcing my candidacy to run for Lonoke County Sheriff. This campaign isn't about me. It's about every parent, every neighbor, every family who deserves to feel safe in their homes and safe in their community. It's about restoring trust, where neighbors know law enforcement is on their side and families know that they will not be left alone in a moment of need. Together, we can build a safer, stronger Lonoke County for every family. I'm Aaron Spencer, and I'm running for sheriff of Lonoke County.
Mm. And here, they actually put in some. Back in October 2024, investigators say Spencer shot and ended 67-year-old Michael Fosler. Spencer had reported his 14-year-old daughter missing, later finding her with Fosler, who at the time was out on bond facing multiple charges tied to the alleged sex SA of that same girl. Authorities say Spencer chased and stopped Fosler's vehicle before opening fire. He was later arrested and charged with second-degree murder. Spencer's pre-trial date is set for December 16, and his trial is set to start January 26. Yeah, when the authorities say this is the state's allegations. Now, we know there's more to this story. We know that Aaron Spencer shouted to his daughter to get out of the truck. We know, at least from from the what's known, at least, that he shouted at Michael Fosler to let his daughter go. We know that there was an altercation where Michael Fosler stepped out of the car and allegedly had something in his hand. That we know. We also know the circumstances. Michael Fosler, 40+ charges of SA and related, grooming of a minor, SA of a minor, serious charges, and was let out on a stupid low bond. So with that background, we also know that he signed over his house just weeks before this. In my opinion, that shows Michael Fosler was not counting on coming home. Now, was this known to Aaron Spencer at the time? Probably not. But as anybody would have done, Aaron Spencer tried to save his daughter from a predator, which ended with a fatality because the justice system didn't do their fucking job. The justice system has let Michael Fosler roam free for 50 fucking years. And now they charge Aaron Spencer for something that, in my opinion, is clearly self-defense of others. As in his daughter, saving her from her predator. Now, she, in self-defense of others, in Arkansas, it does not need to be in lethal danger. It is enough with risk of great bodily injury, greater bodily harm. Michael Fosler, 46 counts of grooming, raping, SAing this minor girl, and now kidnapped her, for taking her away from her house, from her home, to do God knows what. That is, in my opinion, Aaron Spencer protecting his daughter from greater bodily harm. So why does this county choose to more or less, in my opinion, aiding and abetting in the continuing violations against Aaron Spencer and his family and his daughter? Why do they feel the need to protect a known child rapist, a known child groomer? Why? And the judge, as you might know, or if you didn't, in Aaron Spencer's case, is the same judge who let Michael Fosler go on a $5,000 bond. That judge tried to hide this entire case from public view. Arkansas Supreme Court had to step in and say, no, you cannot do this. You cannot do this. Sadly, they did not replace this judge. So it's still the same judge. Still the same judge. And it is mind-boggling for me how they didn't. In my opinion, this judge has a conflict of interest because she is facing political backlash from letting a child groomer walk free for a $5,000 bond and minimal bond restrictions. Why? So yeah, in my opinion, clear conflict of interest, because will she try to protect herself? Yes, because we already know she did, by putting a lock on everything in the Aaron Spencer case and the Michael Fosler case. So it is infuriating, and everybody should be equally infuriated as I am. So there's a lot of people trying to get the word out on the Aaron Spencer case, but somehow on social media, there's, on X, I mean, when I post about other cases, I get decent of these, whatever you call it, reactions and stuff. I get the likes and a lot of, what do you call it, views. What else do you call it? Impressions. But somehow in the Aaron Spencer case, maybe a third. Why? Why is that so? I wish I could tell you why, but I do not know. Is it because of how sensitive the information is? No, I don't think so. I've been covering other cases with similar or worse. I mean, the Long Island serial killer case, huge reactions. And that is objectively a much worse case. But suddenly, this case, Aaron Spencer, why? There's so many why in this case that I cannot for the life of me understand how it is that way. And again, you guys need to help us out. All the people who are talking about this, who are streaming, who are making videos about this, it's about breaking the glass ceiling on this case. Getting more people to talk about it. Usually, this is a request I don't have to do, but in this case, the Aaron Spencer case, I have to. I have to urge for your help. Yeah, as M169 says, this story should be going viral. And it doesn't. How can this case not go viral? It is. Aaron Spencer is a combat veteran. There's a former law enforcement officer involved in the case. It should be much, much bigger than it is. And it isn't. Will it pick up once we get to the hearings and with the coming trial? Maybe, if we are even allowed to have cameras in that courtroom. And remember, this judge tried to stop us from knowing anything about this case. So we are risking here the same as with the Delphi case, that only the information the judge wants public is going to be public. And, you know, I've been covering the Delphi case for years. And I know once the trial was over, I knew the interest would fade. Now, luckily, there's still a lot of people interested in that, and I don't care how few viewers I have on my Delphi case streams. I'm going to keep doing them. But I don't want that to happen to this case. I want us to be there all the time for Aaron Spencer. And this is my contribution to that. When something happens, I will tell you guys about it. But there's not much to. There should be a lot more. There should be a lot more filings. And it's not. I am. It's frustrating. Yeah, Lee Hamilton, thank you. The minor was the only witness in the case. Fosler was most likely going to end the child. And the judge is shady. Extremely shady. Has anyone pulled the docket to see what has been filed? I saw it earlier. Oh, great. I have to go through a VPN, of course. Hold on. Let's see here. Let me get you. Share screen. Stay to on. Dun, dun, dun. Here it is. Docket entries. No document, no document, no document. Here's the criminal information. 2024. Where's the rest? Where's the rest of it? Oh, let me see here. Oh, ignore. All right, here we have some documents. In the circuit, let's make this bigger. Sorry, I'm going to, so you don't see the comments. Motion eliminate to exclude evidence of Spencer's conduct from July 2024 pursuant to blah, blah, blah. This is about Aaron Spencer because he was obviously extremely angry at what was done to his daughter. He was convinced to let the judiciary handle it. And then months later, his daughter, this event happened. Now, the state wants to say, look, he wanted to kill Michael Fosler months before. Hence, murder 2. It was pre-planned. How the fuck do you pre-plan your daughter getting kidnapped? But yeah, let's read through this. Comes now defendant Aaron Spencer by and through his attorney, Michael Keel of Lassiter and Castellini, and for his motion states, decedent Michael Fosler was charged with multiple felony counts for S.A., Spencer's daughter, in this case. Fosler was arrested on July 11th after Spencer's daughter made initial disclosures July 8th, 2024. The state's discovery file contains a report from Lonoke County Sheriff's Office Deputy John Ingram about a meeting with Leanna Higginbotham and her daughter Paula McFarlane on July 8th. The report alleges Higginbotham and McFarlane told Ingram that Aaron Spencer had requested details about their mutual friend, Michael Fosler. And that when Higginbotham and McFarlane asked Spencer why he wanted Fosler's information, Spencer told them that Fosler has raped his teenage daughter and allegedly begged for them to not call the police. Ingram's report then notes he spoke with Spencer at his residence and that he was extremely angry at first and refused to talk to about the alleged rape, but then calmed down and cooperated fully with law enforcement's investigation into Fosler. This court must exclude any reference to or evidence about Spencer's conduct in July 2024 pursuant to blah, blah, blah. Such evidence has no independent relevance and does not fall into any of the listed or known exceptions to Arkansas rules of evidence, general prescription on character evidence. Further, any probative value that the evidence has, which Spencer does not concede, is grossly outweighed by the dangers of unfair prejudice and confusion of the issues. The evidence is not relevant and is inadmissible pursuant to Arkansas Rules of Evidence 401 and 402. Spencer's conduct in July 2024 has no bearing on whether his use of force against Fosler more than 3 months later in response to Fosler's kidnapping, essay, and possibly eliminating his daughter as a witness in his own criminal case was justified. The evidence must be excluded as irrelevant accordingly. Rule 404B of the Arkansas Rule of Evidence provides evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purpose, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Prior backed acts evidence must be independently relevant to the main issue, relevant in the sense of tending to prove some material point rather than merely to prove that the defendant is a criminal. Even if relevant under Rule 404B, evidence may still be excluded under Arkansas Rules of Evidence 403 if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. The state is not entitled to introduce evidence of other offenses pursued to persuade the jury that the accused is a criminal and thus likely to have committed the crimes he's been charged with. Specifically, proof of other crimes is never admitted when its only relevance is to show the defendant is a man of bad character and or addicted to crime. The evidence at issue has no independent relevance to the charged act. Whether Spencer asked associates of Fosler for information about Fosler more than 3 months prior to the charged act, in this case, has no relevance to the charged acts. Whether Spencer was angry and or initially refused to cooperate with law enforcement into the investigation of Fosler, an investigation he then cooperated with fully, has no relevance to the charged act either. Such evidence may be relevant if Spencer was alleged to have stalked Fosler and killed him at his home or out in public. However, that is not what happened here. Rather, Spencer awoke in the middle of the night to find his teenage daughter missing and happened upon Fosler's truck as he turned down his street while out searching for his daughter in his truck. Spencer was not looking for Fosler, rather he was looking for his daughter. He just happened to find Fosler with his 14-year-old daughter mere months after Fosler's arrest for SAing her. What followed was lawful use of force in defense of his daughter and himself. The issue here is whether Spencer validly used force in defense of his daughter and himself, not whether he had any specific intent to kill Fosler prior to the incident at issue. The evidence is inadmissibly accordingly. Instead, this evidence is the worst kind of propensity evidence meant to encourage the jury to find Spencer guilty in accordance with his character, for having sought out Fosler's information to handle the issue himself, despite no actual proof of such, to encourage a vigilante narrative that is simply believed by the actual facts of the charged offense, rather than evidence associated with the charged offense. Any marginal relevance the evidence may have, which Spencer does not concede, is outweighed by the dangers of confusion of the issues and unfair prejudice and must be excluded pursuant to Rule 403 accordingly. The trial would become about whether Spencer has previously sought to handle Fosler himself in July 2024, rather than whether he was justified in killing Fosler in October 2024 following Fosler's abduction of his daughter. The state will be able to argue some sort of pre-existing intent despite no alleged connection between Spencer's July 2024 comments and use of force against Fosler in October 2024. This court must exclude the evidence pursuant to Rule 403 accordingly. The evidence does not fit any exception listed in Rule 404B, and in fact is precisely the type of evidence that Rule 404B exists to keep out. Further admission of this evidence would violate Spencer's due process rights. See Andrew, blah, blah, blah. When evidence is introduced that is so unduly prejudicial that it renders the trial fundamentally unfair, the due process clause of the 14th Amendment provides a mechanism for relief. The court must exclude the evidence at issue accordingly. Wherefore, the defendant respectfully requests that this court enter an order precluding the state from offering any evidence about his July 2024 conduct during the trial in this matter, or alternatively for a hearing whereby the state may specify which exception to Rule 404B it believes applies and where the court may determine whether such evidence will be admissible in jury trial. Respectfully submitted, Michael Kiel Kaiser. Certificate of notice. Let's see here. State's response here. Oh, this is a response to dismiss felony information on Fifth Amendment ground. Let's read the motion to dismiss here first. This is from August. Hey Jen, hey Jay, hey Erica, hey Fondian, hey Sloothy. Motion to dismiss felony information on Fifth Amendment grounds. Let me make this a bit bigger. Comes now. The defendant Aaron Spencer by and through his attorneys at Lassiter and Caselli, and for his motion to dismiss this criminal case under the Fifth Amendment to the United States Constitution states 1. Introduction. The court should dismiss this felony information because it violates the grand jury requirement of the Fifth Amendment to the United States Constitution, and stare decisis is not a license for the state to pursue such an unconstitutional course of conduct. Following the Supreme Court's incorporation of the Sixth Amendment jury unanimity, the requirement in Ramos versus Louisiana, nearly every core criminal procedure protection in the Bill of Rights has been incorporated to the states through the due process clause of the 14th Amendment. The court's incorporation doctrine under the 14th Amendment ensures that the minimum content of due process is not subject to erosion by state legislators. Now, folks, there are a bunch of states that do not have grand jury indictments. Arkansas is one of them. And to my knowledge, Arkansas Supreme Court has verified that Arkansas do not need grand juries. They can go on the prosecution's information alone, which is more or less what we do. We don't have grand juries over here in Europe. What we have, here we go solely by the prosecutions. Now, the prosecution has to go to court once in a while to say, we made progress in the case. That is an absolute requirement to have let the pre-charges keep going. 3. The last unincorporated criminal procedural right is the Fifth Amendment's grand jury clause. Whether to require states to comply strictly with the grand jury clause was last considered in Hurtado versus California. That precedent, if read today in light of recent decisions and historical precedent, cannot justify a process that strips criminal defendant of a foundational procedural protection. Accordingly, Spencer respectfully requests dismissal of the felony information in this case. Argument. The grand jury clause of the Fifth Amendment to the Constitution provides no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. U.S. Constitution, Amendment 5. Like the U.S. Constitution, the Arkansas Constitution contains a grand jury requirement, and so did the 1868 version of the same document. The purpose of the grand jury requirement is to limit the defendant's jeopardy to offenses charged by a group of his fellow citizens according independently of either prosecution attorney or judge. U.S. versus McCarthy. The history of the grand jury dates back more than 1,000 years, from the constitutions of Clarendon and the Assize of Clarendon to the 14th century Edwardian advance in criminal procedural design, interrogating the non-incorporation of the grand jury clause. In the 17th century, the cases of Stephen College and the Earl of Shaftesbury saw the grand jury emerge as a valid protection of individual liberty. This is in England, by the way. I can't talk. I don't know much about British law. Where was I? blah, blah, blah. Against blah, blah, blah. The Supreme Court acknowledged the venerable history of the grand jury requirement, including its presence in Clause 39 of the Magna Carta. Oh. Folks, I've said this in other cases, but once you mention the Magna Carta, rarely, if ever, does a reference to Magna Carta have any bearing on a court case in the United States. And the debates on whether it should be interpreted to include not only felonies, but also misdemeanors and petty offenses. In Hurtado v. California, however, the court ultimately decided not to incorporate the grand jury clause against the states, holding that state legislators were free to newly devise any legal proceeding enforced by public authority, so long as they preserved the principle of liberty and justice. Although Hurtado established that the grand jury requirement was not incorporated against the states, the decision did not excuse states from ensuring that their criminal procedures offered at least some form of due process, and it did not require Arkansas or other states to strike the grand jury requirement from their constitutions. Therefore, in Arkansas and other similar states, the grand jury requirement remained. However, in 1936, Arkansas amended its constitution to provide that all offenses heretofore required to be prosecuted by indictment may be prosecuted either by indictment by grand jury or information filed by the prosecuting attorney. The following year, based solely on the court's decision in Hurtado, the Arkansas Supreme Court found that Amendment 21 was constitutional within the meaning of the 5th and 14th Amendment of the U.S. Constitution, ushering in an era of felony charges being filed by a lone prosecuting attorney. The state's practice of allowing individual prosecuting attorneys to charge individuals with serious criminal offenses directly controverts the 5th Amendment to the U.S. Constitution. It also creates the risk of executive overreach, which have no roots in the history or tradition of this country. Well, we've heard a lot of cases where they overreach. I mean, it's the YSL trial, the Canary trial. Yeah, overreach is the way prosecutors try to get plea deals. They charge you with everything between heaven and hell, claiming to the judge they are dangerous to society, put them in jail, and then after a few years, yeah, but if you plead to this minor offense, we will drop all other things. So yeah, executive overreach is actually quite common. To protect the 5th Amendment right of Arkansas, this court should dismiss the felony information in this case. Although Hurtado did not incorporate the grand jury clause, the rationale of Hurtado has been superseded by subsequent incorporation decisions. The right to grand jury indictment is the sole unincorporated outlier among the due process protections contained in the Bill of Rights. Because of the court's decision in Hurtado Supra, which predated the era of selective incorporation, see Fairfax. Although Hurtado treated incorporation as a matter of procedural due process, the court now applies a substantive due process analysis for incorporating the Bill of Rights. Although Hurtado is critically important to the 28 states, including Arkansas, that allow a defendant to be prosecuted for a felony without a grand jury indictment, Hurtado could be called into question in the light of the court's decision in Ramos, U.S. at 156-57, Alito, Justice Alito dissenting. The courts case the Gypsy Muse. It's like there's some sort of invisible gag surrounding this case. Yeah, I agree. I mean, even before my trip to the United States and when I didn't post as much and YouTube started to think that, oh, he doesn't post anymore and more or less removed it from the algorithm. the Aaron Spencer case is probably the case with the lowest numbers that I have posted anything about. And it's stupid. Absolutely stupid. Again, if you want to help me break through that, hit the like button, make your comments, everything that keeps the algo running, and have me and others break through that glass ceiling. Let's continue. The court's rationale in Ramos reflected the court's rationale in Timms versus Indiana, in which the court explained that the protection enumerated in the Bill of Rights is incorporated against the states if it's fundamental to our scheme of ordered liberty or deeply rooted in this nation's history and tradition. Ramos is a 2019 case. A close reading of Hurtado shows that the court did not deny the fundamental character of the grand jury right. Instead, the court acknowledged the grand jury's deep roots in both United States history and tradition and the English history and tradition that preceded the foundation of this country. The court recognized that the grand jury requirement was a safeguard to the fundamental principles of liberty and justice. What it rejected was not the idea that individuals had a fundamental right to be free from deprivations of liberty exceeding the limitation established in the Bill of Rights, but the idea that the due process clause of the 14th Amendment required identical procedural mechanisms in state and federal prosecutions to preserve the fundamental principles of liberty and justice. Yeah, the actual gag order in this case was removed through Arkansas Supreme Court. Sadly, they did not tell the judge to fuck off, which they should, but they didn't. So it's still the same judge who let Michael Fosler go walk on a stupid low bond, more or less allowing him to do the kidnapping that resulted in Michael Fosler's ending. Let's continue. In doing so, the court avoided conflict with its previous decisions in Murray's lease v. Hoboken Land and Improvement, 1855. In Murray's lease, the court had held that the due process requires adherence to traditional common law procedures demonstrating consistency with fundamental principles rooted in history and tradition. Had the Hurtado court followed this analysis, it would likely have concluded that replacing a grand jury indictment with unilateral procedural information was incompatible with due process. However, the 14th Amendment had only recently been ratified, and California, like other Western states, was struggling with the practical requirements of convening grand juries in sparsely populated areas. In that context, prior to the court's incorporation decisions of the 20th and 21st centuries, the court concluded that California's practice of proceeding on an information filed by an individual prosecutor was not sufficiently unfair and oppressive to violate the 14th Amendment. This deferential procedural due process standard sets Hurtado apart not only from Murray's leasee, but also from the court's more recent incorporation decisions, in which it has reviewed states' criminal procedures as a matter of substantive due process. Spencer's motion does not require this court to overrule Hurtado, only to read it narrowly in the context of Murray's lease. A narrow reading of Hurtado establishes that although a felony information may satisfy the minimal requirements of procedural due process, a substantive due process analysis required dismissal of the felony information in this case. Recent incorporation decision established that Fifth and Sixth Amendment criminal procedural rights apply identically to the states as to federal prosecutions. Sadly, the Arkansas Supreme Court have upheld this situation. Now, we all know that you can indict a ham sandwich through a grand jury because it's only the prosecution story. But then again, if they have presented a truthful case to a grand jury, hey, we are going to charge the dad of a raped minor for murdering the rapist who kidnapped her, actively undergoing a kidnapping. Yeah, I think a lot of people would have a hard time saying, yeah, let's prosecute him. Let's indict him. Even in grand juries. Probably is also the reason, even though they have the option, apparently, in Arkansas, this prosecutor didn't want to. For some misdirected care about, oh, we can't allow vigilante justice. This is not vigilante justice. This is a father protecting his daughter. The prosecutor is a fucking scumbag. As previously established, the Hurtado court did not find the state's process for filing felony charges to be outside the scope of the 14th Amendment due process clause. Instead, the Hurtado court decided that due process meant any process that was legislatively intended to safeguard the fundamental principles of liberty and justice. In the many years since Hurtado, the court has overruled most of its precedents from the 19th century, expressly holding that the 14th Amendment due process clause does, in fact, require that courts apply an identical definition of due process to state prosecutions as to federal prosecutions. This trend reflects that Justice Black was considered to be the original purpose of the 14th Amendment, to extend to all the people of the nation the complete protection of the Bill of Rights. To hold that this court can determine what, if any, provisions of the Bill of Rights will be enforced, and if so, to what degree, is to frustrate the great design of a written constitution from 1947. In 2010, the Supreme Court of the United States published the following list of its decision fully incorporating provisions of the Bill of Rights against the states. Everson versus Board of Education, Ewing. Cantwell versus Connecticut. DeYoung versus Oregon. Gitlow versus New York. Nervis versus Minnesota. Aguilar versus Texas. Mapp versus Ohio. Yeah, there's a lot of cases. In 2020, the court added the Sixth Amendment's implied requirement of jury unanimity to its list of provisions from the Bill of Rights. That applies identically to states. Ramos versus Louisiana. In Ramos, the court acknowledged that the unenumerated jury unanimity requirement had never previously been applied to the states. Even in Apodaca versus Oregon, a 1972 case directly on point, citing Apodaca versus Oregon, 1972. Nevertheless, the Ramos court expressly overruled Apodaca and found that the Sixth Amendment required jury unanimity both in federal prosecution and in state prosecution. It did so despite the thousands of cases in which state court had relied on Apodaca, despite the potentially crushing burden on the courts and criminal justice system, and fully incorporating the jury unanimity requirement might impose on states. Hey, Jan the Couch Fairy, saying I'm doing my part to get this case and its channel back on favorable sides of the dreaded algo. Thank you so much. Thank you so much. Yeah, the gag order that was in place took the case out of the spotlight. There was nothing to cover. Hopefully that will start to turn around and coverage will pick up again. I really, really hope so. I really, really hope so. The Ramos court explained that once a right has been incorporated against the states by the 14th Amendment, that right cannot be interpreted to mean two different things depending on whether it is being invoked against the federal or a state government. Thus, Ramos should be read implicitly superseding Hurtado by prohibiting states from obtaining felony criminal convictions by procedures that, although they may be arguably consistent with the principles of justice, liberty and justice, are not identical to the federal government's criminal procedures. 4 years after Ramos, the court explained the crucial importance of the jury trial rights, both enumerated and unenumerated, of the Fifth and Sixth Amendment. Thus, The Sixth Amendment promises that in all criminal prosecutions, the accused has the right to speedy and public trial by an impartial jury. Inherent in that guarantee is an assurance that any guilty verdict will issue only from an unanimous jury. The Fifth Amendment further promises that the government may not deprive individuals of their liberty without due process of law. It safeguards for criminal defendants well-established common law protections, including the ancient rule that the government must prove to a jury every one of its charges beyond a reasonable doubt. Together, these amendments place the jury at the heart of our criminal justice system and ensure a judge's power to punish is derived wholly from and remains always controlled by the jury and its verdict. Although the court's justices have offered somewhat different explanations for the court's recent incorporations decision, the message is clear. State must comply with the jury requirements contemplated by the framers, or their action will be found unconstitutional upon review by the Supreme Court of the United States. The McDonald's case, this court has abandoned the notion that the guarantees in the Bill of Rights apply differently when incorporated against the states than they do when applied to federal government. Justice Alito, writing for the plurality in McDonald, argued the well-settled principle that fundamental rights guaranteed in the Bill of Rights are incorporated against the states by the 14th Amendment Due Process Clause. Justice Thomas concurred with Alito's plurality, but he opined that complete incorporation was necessitated by the plain language of the 14th Amendment privileges or immunities clause rather than the due process clause. Thomas J. concurring in part and concurring in judgment. Thomas repeated his argument in his Ramos concurrence 10 years later. Regardless of which clause the court prefers, both analyses point toward finding that the 14th Amendment requires Arkansas to strictly comply with the 5th Amendment grand jury clause. Since the Hurtado Court determined that the 14th Amendment Due Process Clause governs the review of how a state files serious criminal charges against individuals like the defendant in this case, and the Ramos Court determined that the Due Process Clause requires uniformity in the protection of constitutional rights between the state and federal criminal justice system, these two cases taken together suggest that the state's failure to comply with the Fifth Amendment's grand jury clause incorporated under the Due Process Clause requires the dismissal of the felony information in this case. Likewise, since the plain language of the 14th Amendment privileges or immunities clause provides that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, end quote, and the requirement of the Fifth and Sixth Amendments, both enumerated and unenumerated, protect individuals from deprivation. From deprivations of liberty imposed by an individual representative of the executive branch rather than a jury. The language of the U.S. Constitution suggests that a state may not, as here, file felony charges leading to the arrest of an individual like this defendant with any process involving a greater risk of arbitrariness than putting the question to a grand jury. Let's see. Yeah, and this, it keeps going and keeps going and keeps going. They quote a lot of cases. Now, let's go to the conclusion. An individual's Fifth Amendment right to be free from serious criminal charges except those charged by the indictment of a grand jury shields not only this defendant, but all of us from exactly the sort of deprivations of liberty without due process that the framers sought to prevent. Rather than continuing down the path of affirming a prosecutor's purported power, even when it contravenes the express will of a grand jury, to unilaterally charge people with capital crimes and other serious felonies, this court should look at the language and intent of both relevant constitutions with due consideration to the development of constitutional law in this area since 1884, and it should find that the felony information in this case violates the Fifth Amendment's grand jury clause as incorporated by the 14th Amendment. Wherefore, the defendant Aaron Spencer respectfully requests that this court dismisses the felony information in this case for violating the Fifth Amendment grand jury clause. Now, what speaks against? This is Arkansas Supreme Court allows this. And to my knowledge, no case have gone to the U.S. Supreme, gone up to SCOTUS. Yeah. BB put up a video that Aaron Spencer is running for sheriff. I haven't watched it yet, but that should be getting some attention. Running for sheriff while charged with murder. Don't see that every day. No, you don't. We went through that before we started reading from the documents. So you have it here. Just go back. I have no idea when the timestamp of that, though. But if you go back, you can see us going through, go through that. Now, of course, the state answered. State's response to defendant's motion to dismiss felony information on Fifth Amendment grounds. Comes the state of Arkansas by through prosecuting attorney Chuck Graham. Chuck, you're an asshole for prosecuting Aaron Spencer. Why do you protect Aaron Spencer's daughter's rapist? Why? And for his response to defendant's motion to dismiss felony information on Fifth Amendment grounds hereby states, argument. Spencer's motion to dismiss has framed the state's filing of a criminal information in this case as a failure to comply with the Fifth Amendment. This is not so. 28 states currently file criminal charges by information. When indictment is required, state prosecutions, grand jury law and practice, paragraph 8.2, the current controlling state and federal precedent does not require states to use grand juries. Spencer's reliance of Ramos versus Louisiana is misplaced. Ramos concerned the requirement of a unanimous verdict in trials by juries under the Sixth Amendment, not the mode of charging under the Fifth Amendment. That decision did not overrule Hurtado versus California, which clearly held that the states do not have to indict by grand jury. Yeah, here are the states that does not have grand juries. Arizona, Arkansas, California, Colorado, Connecticut, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Maryland, Michigan, Missouri, Montana, Nebraska, Nevada, New Mexico, North Dakota, Oklahoma, Oregon, Pennsylvania, South Dakota, Utah, Vermont, Washington, Wisconsin, and Wyoming. That's more than half the states, by the way. Do I believe that the grand jury should be in every state? Yeah. But more important is vote out idiot prosecutors. Hold them accountable, even though they have all the immunities unfairly, in my opinion. Go vote. If you have a prosecutor acting like this idiot, vote for somebody else as district attorney. Vote for somebody else. While Spencer's motion presents scholarly argument that under modern incorporation jurisprudence, the grand jury clause should be recognized as fundamental, those argument remains outside the holdings of controlling precedent. This motion must fail as a matter of current constitutional law. While Spencer alleges that he is not requesting this court to overrule Hurtado, that is what would be required in order to grant Spencer's motion. It is well settled that states are not required to charge by indictment, but may charge by information, referencing Hurtado. The Arkansas Supreme Court has addressed this issue many times and has consistently refused to extend the right to grand jury indictment to proceedings in this state. Yeah. Oh. While much of the case law that has reiterated this well-settled matter is prior to the Ramos ruling, the Arkansas Supreme Court has stayed consistent even since Ramos was decided. That Ramos' opinion was issued April 20th, 2020. The defendant in Waller v. State, which was issued November 2020, filed a pro se petition for writ of habeas corpus. The defendant had been convicted of first-degree murder, arson, and first-degree battery. Among other arguments, the defendant alleged in his petition and in his argument to appeal that no grand jury indictment were issued for the charges of arson and battery. At that time, the Arkansas Supreme Court reiterated, citing both Barber v. Kelly and Hurtado, post Ramos, that the right to grand jury indictment proceedings does not extend to the state of Arkansas. Yeah, but you're a bit off here. He only asked for the arson and battery. But, yeah. Wherefore, the state of Arkansas respectfully requests that its honorable court deny the defendant Aaron Spencer's motion to dismiss. And I have to say that it will probably be dismissed. There simply are, in Arkansas, enough case law for this. Let's see here. Let's go through the criminal information so we know what the prosecution actually alleges here. November 27th, 2024. I, Chuck Graham, also known as Asshole, prosecuting attorney within and for the 23rd Judicial District of the state of Arkansas, which consists of Lonoke County, in the name of and by the authority of the state of Arkansas, blah, 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 blah. The state of Arkansas alleges that on or about October 8th in Lonoke County, the defendant, count one, did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life. He valued his daughter's life. Do you think of that? Chucky, you cunt. Class A felony. To wit, Michael Fosler against the peace and dignity of the state of Arkansas. Enhancement. Any person convicted of any offense that is classified by the laws of the state as a felony, who employed any firearm and any character as means of committing or escaping from the felony in the discretion of the sentencing court may be subjected to additional period of confinement in the state penitentiary for a period not exceeding 15 years in violation. So not only are they charging him with second-degree murder, they are asking for enhancement. You asshole. Here is the notice of from the defense. Notice of intent to raise justification as a defense. This is self-defense. Comes now the defendant Aaron Spencer by and through his attorneys, Aaron Casalini and Michael Kiel-Kaiser of Lasseter and Casalini, and for his notice of intent to raise justification as a defense states and alleges as follow. The defendant is charged with a felony offense. The defendant does indeed intend to raise justification as a defense under Arkansas Code, blah, 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 in the above reference case. Wherefore, the defendant is hereby giving notice to the state and to the court of his intent to raise justification as a defense in this matter. Here's one of the scheduling order. Here is the motion for the gag order. Comes now the state of Arkansas by John Higgins, Chief Deputy Prosecuting Attorney, and for his motion for gag order. Aaron Spencer is charged with murder in the second degree and felony with a firearm. That these charges stem from his arrest. That defendant Spencer's arrest has garnered garnered media attention and coverage throughout Arkansas and the nation. Oh, boo fucking who? Oh, are people noticing that you're assholes? John Higgins and Chucky? No. Additionally, details of his arrest have spread via social media. Duh. The defense counsel have issued a press release. Yeah. The defense counsel has also given television interviews. In one interview, counsel stated, "We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or member of the family." Attorney Casalini went on to say, "We look forward to the public being more involved in this process, certainly more than they were today." That the state argues that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendants and the states of Arkansas to receive a fair and impartial trial. You don't give a flaming fuck about the defendant. This is you. What fuck was your name again? John Huggins. You're scared. That's it. And the states do not have a right to a fair trial. They have the obligation to conduct a fair trial. This absolute tomfuckery, seriously, with the states act, oh, we need a fair trial too. No! The defendant has the rights. The state has obligations. Jesus Christ, I hate this. And then this kind of bullshit happens. We've heard it in many trials. Oh, the state needs a fair trial too. You are the ones that are charging the defendant. You are the ones that has obligations. The only person in a courtroom that has rights is the defendant. That's the only one. Yeah. That line makes me furious every time I hear it, says Jan. Yeah, I agree. Fuck that. That the need to preserve the integrity of Europol is paramount importance to ensure the right of a fair trial to both the state and the defendant. Didn't the prosecution made a press release? We are charging this man with second-degree murder. We believe he did it with indifference to human life. Yeah, you did. Yeah, you did. But the moment you saw that, oh, we are getting, people don't like us. Gag order. Please, judge. Gag order. The state prays. No, you fucking don't. There's only one. Well, depending on which religion. You don't pray to the court. You ask the court. Jesus Christ. That the court ordered that no party to this action, nor any attorney or agency connected with this case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement official, nor any agent, deputy, or employee of any such persons, nor any person subpoenaed to testify at the trial of the case. Who's the fucking agent? Huh? If the court says, oh, these social media figures, they are actually agents of the defendant, which was basically what the judge concluded. Shall exercise or authorize the release for public dissemination, blah, 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 blah. Make any statement outside of court for public dissemination as to the weight, value, or effect of any testimony that has been given. express outside of the court and an opinion to make any comment for public dissemination as to the weight, value, or effect of any evidence as tended to establish the guilt or innocence of the defendant. Seriously, you fucktard. This is a prosecutor in full-blown panic. They want to convict this guy for protecting his daughter against a known predator. Wherefore the state prays that its motion for gag order. Why? Why that word? The judge, the court are not anointed by God. You don't pray to court. You pray to God, whatever God you seem fit. You don't pray to the court. Jesus fucking Christ. Sorry. Yeah, I know that once in a while somebody complains about me taking the Lord's name in vain. It will happen again. Response to motion filed. Let's see here. Response to state's motion for gag order. Comes now the defendant, Aaron Spencer, by and through his attorneys, Erin Casolini and Michael Kaiser, and states for this response to the state's motion for gag order. On November 27th, 2024, the states of Arkansas charged Spencer with murder in the second degree, with an enhancement adding up to 15 years imprisonment for using a firearm in connection with that offense. The charges resulted from the October 8th death of Michael Fosler. The case has garnered media attention because Spencer killed Fosler while Fosler, having already been arrested and charged with numerous offenses against Spencer's child, had Spencer's minor daughter in his custody for the purpose of raping her or worse. Fosler has previously been arrested and charged with 43 felonies for his conduct with Spencer's daughter, including internet stalking, SA, and CP. This court released Fosler on a paltry fund, with an order that Fosler could not have contact with the Spencer family. Undeterred by his arrest, Fosler continued his crimes against his child. About 3 months later, after finding his daughter missing in the middle of the night and contacting police, Spencer located her with Fosler, who fled with her in his truck. After Spencer pushed Fosler's truck to a stop, Fosler continued to present an imminent threat to Spencer and his minor daughter, the key witness in Fosler's pending criminal case, and Spencer ended Fosler, saving himself and his daughter from further harm at Fosler's hand. Denise says, Nick, it would be nice if you could give us a hint of when you're not happy with people regarding cases. I will try to be more clear. Yeah, Ronan. Jesus can take care of himself, doesn't need any of us to defend him. Yeah, at end of days, we will be shown if we did good or bad. And I will guess there will be a lot of people being very surprised of where they're going, including but not limited to the prosecutors and the judge in this case. As it turns out, although he was never convicted of a crime, Fosler was known by others both in Arkansas and other states as being depraved. As can be expected, the Lonoke County community, including the Spencers, has been outraged by both Fosler's lenient treatment and Spencer's unjust charges. Even before the filing of these charges, significant media attention was generated as citizens in Lonoke County and throughout Arkansas reacted with outrage to Spencer's arrest. In light of the obvious public interest in this case, individuals associated with both the defense and the state made statements to the press. Despite an initial willingness of state actors to engage with the press and the public about the heavily criticized decision to file charges against Spencer, the state has now reversed course and requested this court issue a gag order preventing Spencer and others, including public officials or police, from exercising the constitutional right to free speech. The state's aim is clear. By silencing Spencer and his supporters in the community, it might also dampen media interest in Spencer's fight for justice, thereby shielding the state from public scrutiny and creating an easier path to the conviction and imprisonment of an innocent man. Gag orders are not intended to protect public officials from criticism. The facts of this case are not in great dispute. It seems from the state's comments and the charge that it will seek to suggest that Spencer killed Fosler solely out of anger and revenge instead of fear, despite the undisputable facts that led to Fosler's death. It is, of course, the state's prerogative to choose charges and theories. However, this theory is entirely inconsistent with the law. The Spencers, like any parents of a child harmed by a predator, were certainly angry and upset by Fosler's abuse of their child. But even if he wanted to, Spencer did not end Fosler after finding out about the abuse. He let the justice system proceed to stop and punish Fosler. But when the system failed and Fosler took the child to harm her further, angry or not, Spencer did what was necessary and justified to save her. The law certainly does not require that a person who acts in self-defense or defense of others be docile or loving towards the person they must harm in order to save themselves or others. Instead, the law requires only that he reasonably believed the other person was committing or about to commit a felony involving force or violence, or was using or about to use unlawful deadly physical force, or where it was necessary as an emergency measure to avoid an imminent public or private injury. And according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweighed the injury sought to be prevented by the law prescribing the conduct. Arkansas Code, blah, blah, blah. Once raised, the state must disprove a justification defense beyond a reasonable doubt. Thus, if there is any doubt that the defendant's action may have been justified, that is, he feared for his or another's physical safety, the accused is not guilty. Further, while a defendant's intent or purpose, that is, their state of mind, is typically not positively known to others, it can be inferred from the circumstances, and the jury may draw on its own common knowledge and experience to infer it from the circumstances. Here, there is little doubt that Spencer was justified in ending Fosler, and no reasonable person using common sense would consider these circumstances and find that Spencer was not fearful for the safety of his child at the hands of a man who had repeatedly hurt her for months. The state's effort to retool the facts of this case by insinuating they have evidence otherwise and preventing the public from knowing what is plainly the reality should be rejected. Although it is easy to think that an order restricting public commentary would make this case less onerous for some of the participants, the Constitution and our system of justice demand that urge be resisted for the benefit of the defendant and the public. If granted, the state's gag order would represent a clear violation of Spencer's constitutional rights of free speech and a fair trial. The state's motion must be denied. And then they go through the legal principles with a lot of case law. Let's see here. This was a long ass. Let's go to the conclusion or the argument. On December 4th, 2024, in an apparent attempt to cast a shadow of silence over these proceedings and suppress public support for Spencer's fight for justice, the state filed a motion for gag order which, if granted, would impose an extreme restriction of free speech, preventing Spencer, as well as his attorneys, potential trial witnesses, and even public official with no connection to the trial from speaking to the press or to the public about this case. The state's proposed order would foreclose all speech about the case other than what the state itself has already disseminated to the public. For instance, the state has already publicly shared the factual background of the defendant, the circumstances of the arrest, including the place, time, arresting agency and officer, and the nature, substance and text of the charge, and its own description of the offense charged. the proposed order permits what the court cannot even arguably constitutionally prohibit from disclosure. That is, quotations from public records or information already in the public domain. But the judge did. We know that now. Scheduling in this proceeding that is done in public request for assistance in obtaining evidence, i.e., a constitutionally required investigation of the matter, and discussions by prospective witnesses with attorneys in the case, also constitutionally require a component of representing a criminal defendant. So the state seeks to foreclose anything other than what it puts out in the public domain from seeing the light of day. The state complains in its motion of comments defense counsel made when exiting the courthouse after arraignment. These comments have no ability to prejudice a jury, particularly one to be empaneled many months from now. They reiterate the law in this country, where the community matters. In fact, the statement does not violate the proposed order submitted by the state with this motion. If the state is suggesting that the statement meant that the defense is confident that Spencer will be acquitted, prohibiting such statement would be an outrageous violation of a defendant's right to publicly proclaim his innocence. The community has shown support for Spencer, and his family needs that support after what they have been through at the hand of Michael Fosler and now at the hands of the government of Lonoke County. Based on the facts of this case, it is not prejudicial to say that the community's reaction is appropriate, and we expect it to endure. The community is entitled to attend public proceedings, to voice opinions through the media and through elections of public officials, and to use those and other lawful means to support other citizens. Here's the footnote from above. Interestingly, the state seeks to prohibit comments about public records, which would include, for example, criticism of state action in the case, like this motion for gag order by the prosecutor or the court, which has no bearing on guilt or innocence. Quashing public criticism of public officials about public business is far afield of the First Amendment. Right, let's continue. The community has a right to know what its government does in court proceedings. As counsel indicated at the closed arraignment in this case, the public must be permitted to attend future court proceedings. Quote, the sittings of every court shall be public, and every person may freely attend the sittings of every court. It is not in any way prejudicial to say that we hope the community is involved in that manner, the very manner the Constitution itself demands. The Constitution also gives citizens the right to speak about the operations of the government, particularly about criminal prosecutions, to promote transparency and, quote, guard against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism. Quoting a Trump case. Further, the absence of a jury, long recognized as an inestimable safeguard against a corrupt or overzealous prosecutor and against a compliant, biased, or eccentric judge, Duncan v. Louisiana, makes the importance of public access to a preliminary hearing even more significant. People in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. The public should be present for a defendant's public plea of not guilty, but that was not permitted in this case. And now the state is attempting to prevent the defendant from even telling the public he is not guilty. Hey, Montana Lid, caught alive. Yay, yay! Nice, good to have you here. Let's see here. Dun, dun, dun. Hi, Slidey Pie over at Rumble. Hello, folks over at Twitch. Hope you're still here. Hit the like button, folks, by the way. Get us through the algo glass ceiling. Where was I? This request is not about protecting the integrity of the jury pool. There are mechanisms far less restrictive than essentially blanket prohibition on speech that allow the state to do just that. This is really about the state shielding itself from public scrutiny, about keeping the public from knowing about Fosler and how he had the opportunity to repeatedly rape a child even after being shot for doing so, and about Spencer being able to challenge the state's public assertion that he killed Fosler without justifiable cause. Folks, although everything, I agree with everything here, remember, this is the same judge who let Michael Fosler go on a $5,000 bond. They are essentially criticizing this judge, which, yeah, the judge retaliated with a gag order that was viciously overturned by the Arkansas Supreme Court, sadly without removing her as the presiding judge. And about Spencer being able to challenge the state's public assertion that he blah, blah, blah. This is about withholding from the public information that has great relevance to the public's evaluation of the practices and decisions of the local law enforcement community, including the prosecutor. It is about shielding public officials from criticism. But the Supreme Court has made clear that criticism of public official, quote, does not lose its constitutional protection merely because it's effective criticism, and hence diminishes their official reputations. The fact that the state allowed Michael Fosler to repeatedly rape a child and released him with no meaningful restrictions that would have discouraged, if not prevented him from continually to SV children. The state failed to investigate him fully and to find out the full extent of the risk he posed not only to the Spencer child, but to other children in the community. Then the state placed blame on Spencer for his having to intervene when Fosler struck again. The community deserves to know this information and to evaluate the propriety of its government officials' decision in light of it. The community also deserves to be informed and to be heard on the result of these systematic failures. This motion by the state seeks to keep the community in the dark so that it cannot judge the action of its official, and so that it, in the state's view, may not support a community member who had to protect his family where the state did not do so. As laid out above, courts have made it clear that such a restriction is presumptively unconstitutional. To overcome this presumption, the state must demonstrate and the court must find on the record that for Spencer to speak publicly in his own defense and for the press to publish it would pose a significant and imminent threat to the ends of justice, and that public commentary by others involved or expected to be involved in the trial would mean a substantial likelihood of material prejudice to the proceeding. And there must be some explanation provided as to why the court believes it would be futile to employ more constitutionally sound strategies, such as thoroughly questioning potential jurors to root out any whose neutrality has been contaminated by press coverage. Even then, it is not enough that these other strategies would fail. It must also be the case that the proposed strategy, some restriction on free speech, would succeed in strengthening the integrity of the proceeding. And if the circumstances are truly so dire as to warrant such a restriction, that restriction must not overstep by even an inch the reach of its usefulness. Ultimately, the restraints imposed and the exact degree to which they are imposed must be found to provide the only pathway to a fair trial. The state has not even begun to meet this heavy burden. Indeed, the motion lacks any law or legal analysis, make it seem as if the state feels no need or obligation to do so. As a justification for its request to muzzle Spencer, the state points to media attention and coverage throughout Arkansas and the nation, as well as public discussion on social media, as though Spencer is somehow to blame for the widespread interest in this case. It should be obvious that media coverage and public attention go hand in hand, and were both foreseeable consequences of the state's decision to bring murder charges against a father for defending his minor daughter from a predator. The state also cites statements by defense counsel to the press, but fails to mention the prosecutor's own public comments or that the circumstances of the alleged crime were released to the public. In fact, it would be a complete abrogation of duty for defense counsel to say nothing when the prosecution implies that Spencer's actions were motivated by something other than the immediate need to protect his daughter. Furthermore, the state's desire to minimize its failure to appreciate the danger Fosler posed is precisely the kind of information that should be discussed openly and publicly. The state should not be permitted to use this theoretical possibility of interference with a fair trial to shield itself from criticism for failures and imprudent decisions. It is Spencer's right to defend himself from these allegations by asserting his innocence, and his refusal to roll over does nothing to undermine the criminal justice process. The integrity of the trial process is only strengthened by press coverage and public oversight. In fact, the state cannot even bring itself to claim a significant and imminent threat to a fair trial, as would be required to warrant the restraints being requested here. Finding no imminent threat, the state offers an imagined one, arguing in its motion that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. Emphasis added. It is of little import that public communication may reach the ears of those citizens who might eventually serve as jurors in this case. The First Amendment does not bend to mights and maybes. Without a compelling state interest, represented by a real threat to the integrity of these proceedings, the state's unconstitutional request for free speech restraints should be summarily rejected. Even if the court were to agree that possible future communication poses an imminent threat to these proceedings, the remedy requested by the states is by no means narrowly tailored to address such a concern. The proposed gag order is absurdly broad. It would prohibit public comment on anything that might be considered relevant to Spencer's defense and would shield the court and the state from the exact sort of public scrutiny a fair criminal justice system demands. By banning mention of any possible evidence that would support Spencer's actions, the proposed order effectively prohibits public criticism of the mystifying decision to release Michael Fosler back into the community with little restriction after it should have been determined that he was dangerous, or of the state's unjust decision to accuse Spencer of murder. By preventing discussion of evidence tending to establish innocence, it prohibits really any comment about the case that anyone would care to hear. Worse still, for Spencer to even say the words, "I am innocent," publicly would violate the proposed order. And it goes on and on and on here. Wherefore, for the reasons stated above, the defendants respectfully request that the state's motion for gag order be denied, and for all other just and proper relief to which he is entitled. Now, we know what the judge did. The judge went beyond the request from the state. Let's see if this... motion of gag order. Order. Let's see if this is the order. Now, if you weren't pissed off before, you're going to be this now. Order. In view of the apparent public interest in this case and extensive news media coverage as a result of such interest, and because it appears to the court that the dissemination by any means of public communication of any out-of-court statement relating to this case may interfere with the rights of the defendants and the state of Arkansas to receive a fair and impartial trial, and further to seek a fair balance between the constitutional guarantees of a free press, the following order is hereby entered. It is the order of this court that no party to this action, nor any attorney or agency connected with this case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement officials, nor any agent, deputy, or employee of any such persons, nor any person subpoenaed to testify at the trial of this case. Neither shall the defendant nor his family shall to any of the following. This, folks, is everyone. Because here it is directly or indirectly. Anyone. Shall release or authorize the release for public dissemination of any purported extrajudicial statement of the defendant relating to this case. Release or authorize the release of any documents or exhibits or any evidence, the admissibility of which may have been determined by the court. Make any statement for public dissemination as to the existence or possible existence of any document, exhibit, or any other evidence. Express outside of the court an opinion to make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. Remember, no party, nor any attorney or agency connected with this case, directly or indirectly. Everyone. Make any statements outside of this court for public dissemination as the weight, value, or effect of any testimony that has been given. Issue a statement for public dissemination as to the identity of any prospective witness or the probable testimony or the effect thereof. Make any out-of-court statement for public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation of this matter. Make any statement for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. This will be read in the context of directly or indirectly. This order does not include factual statements of the defendant's name, age, residence, occupation, or family status. The circumstances of the arrest, namely the time and place of arrest, the identity of the arresting and investigating officers and agency, and length of the investigation, the nature, substance, and text of the charges, including a brief description of the offense's charges, quotations from or any reference without comment to public records of the court in this case or to other public records or communications heretofore disseminated to the public. So she excludes what the state already published. Everything else. The scheduling and result of any stage of judicial proceeding held in open court or in an open or public session, any request for assistance in obtaining evidence, discussion by any witness or prospective witness of any matter in connection with the case, with any of the attorneys representing the defendant or the state, all parties, and the defendant is under a gag order. All parties and the defendant is under a gag order. And that has to be read in the light of this statement. No party to this action or any attorney or agency connected with this case directly or indirectly. Meaning everyone. A copy of this order shall be attached to any subpoena served on any witness in this matter, and the return of service of the subpoena shall include the fact of service of copy of this order. In addition, any information violating this order shall be redacted from any paperwork related to the case that might be disseminated to the public. This order shall be enforced until this case has been disposed of or until this court orders otherwise. This order will help ensure all parties get a fair trial. The online case is now sealed. This order shows me that this judge tries to protect herself. As we read in the previous one, the defense brings up the circumstances. And the circumstances is that this judge, Barbara Elroy, what's her fucking name? Barbara Elmore, she, by her choice of releasing Michael Fosler on a shit bond and barely any restrictions, created this situation. She is trying to protect herself. Let's see here if we can find. Let's see if I can find the. The Supreme Court decision. Ah. Why can't I make it bigger? Okay, this is the best I can do. Aaron Spencer versus State of Arkansas petition to writ of blah blah blah. Yeah, here's the decision. Petition for writ of certiorari granted, writ issued, circuit court's gag order vacated. Yeah, fuck you, Barbara. Aaron Spencer has filed a petition for writ of certiorari requesting that a gag order entered in this Lonoke County Circuit Court criminal case be vacated. He argues that entry of the gag order was a plain, manifest, clear, and gross abuse of discretion, and that there is no other adequate remedy but for the writ. We agree, and we grant the petition for writ of certiorari and vacate the circuit court's gag order. Background. On November 27, 2024, Spencer was charged by felony information with second-degree murder, along with a firearm enhancement under Arkansas Code annotated section blah 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 for the shooting death of 67-year-old Michael Fosler. The state alleged that on October 8, Spencer knowingly caused Fosler's death under circumstances manifesting extreme indifference to the value of human life, a Class A felony under Arkansas Code, and blah blah blah. The circumstances of the shooting were as follows. In July 2024, Fosler has been charged with numerous SA offenses against Spencer's teenage daughter, and he was released on bond. On the night of the shooting, Spencer awoke to his dog barking and realized that his daughter was gone. Spencer found a hoodie on a stuffed animal placed in her bed. As a result, he left in his truck to search for her. Now, they don't put in here that Aaron's wife called 911 as he went out looking for his daughter. As a result, he left in his truck to search for her. Spencer located Fosler's truck with his daughter inside and is forced Fosler's truck off the highway. After an altercation, Spencer called 911 to report that he had shot Fosler. Fosler died at the scene. On December 4th, the state filed a motion for gag order, alleging that Spencer's arrest had garnered media coverage throughout the state and the nation. Attached to the motion was a press release from Spencer's attorneys, Erin Casinelli and Michael Kaiser, criticizing the decision to charge Spencer criminally as, quote, targeting a heroic father. The state also pointed to a television interview in which defense counsel allegedly stated that they felt confident that the community would side with Spencer, quote, because every one of them would have done the same thing for their child or their neighbor's child or member of their family. The state argued that a gag order was necessary to preserve the integrity of the jury pool and to ensure the right of a fair trial for both the state and the defendant. The state proposed 8 content-based limitations on the speech of any party, any attorney, or agency connected with this case, directly or indirectly. Any judicial employee or officer of the court, any public official now holding office, including but not limited to law enforcement officials, their agents, deputies, or employees, and any person subpoenaed to testify in the trial of the case. On December 9th, Spencer filed a detailed response in opposition to the motion for gag order. He ordered that granting the motion for gag order would violate his due process rights to a fair and public trial pursuant to 6th and 14th Amendments, as well as his First Amendment's right to speak pursuant to both Arkansas and the United States constitutions. Spencer requested a hearing on the state's motion to be held in open court. On December 10th, without holding a hearing, the circuit court entered the order at issue, noting the, quote, apparent public interest in this case and the resulting extensive news media coverage. The court granted the state's motion with some modifications. As grounds for the entry of the order, the court stated, quote, it appears to the court that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. The court further noted it was, quote, seeking a fair balance between the constitutional guarantees of a free press. The order implemented the 8th prohibition requested by the state. And the order included several notations handwritten and initialized by the judge, including the addition of Spencer's family. Now, we already went through this. The order goes on to require, 1, that a copy of the order be attached to any subpoena served on any witness in this matter, and 2, redaction of any information violating the gag order from any paperwork related to the case that might be disseminated to the public. The order further states that it will, quote, be in force until this case has been disposed of or until this court orders otherwise. This order will help ensure all parties get a fair trial. Finally, the order provides that, quote, the entire case is now sealed. Thus, the circuit court adopted the requested prohibition contained in the state's motion for gag order with the qualifications listed in the provisions 1 to C and the sua sponte sealing of the entire case. On February 2nd, 2025, Spencer filed in this court a petition for writ of certiorari and for other relief. The state filed a response on February 12th, and Spencer later filed a motion to stay proceedings in the circuit court, take the petition as a case, and set a briefing schedule pursuant to Arkansas Supreme Court rule. Here's another footnote. We note that this order is nearly identical to the orders we vacated without written opinion in Arkansas Democrat Gazette, Inc. versus State of Arkansas. Petition for writ of certiorari granted. Although the present order does not expressly apply to media outlets, the 8th prohibition on speech and the 7 provisions for information not prohibited by the order use the same language as in the Arkansas Democrat Gazette gag orders, styled orders regarding publicity. Arkansas courts shall no longer use this apparent form order. What was wrong with it? I don't know. Sometimes YouTube has its own thing going on. So I don't know which is. Let's see here. Nick, is it documented what bond Spencer was released upon? No, I don't think so. At least, if somebody finds it, please send it to me. But it was a $50,000 bond, 10% cash, so $5,000, and his restrictions were to not contact the family, the Spencer family. To my knowledge, he didn't have an ankle bracelet even. Virginia says 150K. So why was he released on five? To my knowledge, he only paid $5,000 bond. Huh. That's weird. But Virginia usually has the correct information. Let's continue. Spencer also requested oral argument. We granted Spencer's motion to stay proceedings in the circuit court, took the petition for writ of certiorari as a case, set a briefing schedule, and granted Spencer's request for oral argument. The petition is now ripe for decision. A writ of certiorari is extraordinary relief. Two requirements must be satisfied in order for this court to grant a writ of certiorari. First, a writ of certiorari lies only when 1. It is apparent on the face of the record that there has been a plain, manifest, clear, and gross abuse of discretion, or 2. There is lack of jurisdiction, an act of excess of jurisdiction on the face of the record, or the proceeding are erroneous on the face of the record. I.d. Second, there can be no other adequate remedy but for the writ of certiorari. This court has held that a writ of certiorari is appropriate remedy when a prior restraint of speech is a plain, manifest, clear, and gross abuse of discretion. Analysis. Yeah, Fosler was 5,000. Spencer was 150,000. Yeah. Fosler had to pay $5,000. I believe his bond was $50,000, which he posted, then stayed hidden for 3 months while he signed over the house and his assets to his daughter, and then acted on the only witness in the case against him. Thank you, Crazy Cat Lady. Analysis. Spencer argues that the gag order violates the First Amendment because it is an unjustified prior restriction on certain content-based categories of speech. He further argues that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. The state responds that the circuit court's order was within constitutional limits, protects the integrity of this case, and ensures a fair trial of both Spencer and the states. For the reasons that follow, we hold that the circuit court's action in entering the challenged gag order was on its face a plain, manifest, clear, and gross abuse of discretion and in excess of its authority. Further, there is no other adequate remedy except for a writ of certiorari. Standing. As an initial matter, we must address the state's argument in its response brief that Spencer lacks standing to challenge the order based on constitutional rights of others. Indeed, as a general matter, constitutional rights are personal rights and may not be raised by a third party. However, the issues raised in this petition for extraordinary writ require us to consider restriction not directed towards Spencer personally, and we decline to uphold any part of the order in light of the order's clear lack of an evidentiary basis as a whole. Here, the circuit court's order is extremely broad as to the person's restraint from speaking. It restrains the parties, their attorneys, any public official now holding office, along with the staff, witnesses, court staff, and the defendant's family. The order is also extremely restrictive as to what information is being shielded from public view. It restricts filing and perhaps courtroom proceedings from public view. The order implicates Spencer's right to a public trial as well as the public's right to know how its officials are conducting conducting these criminal proceedings. The state points out that Spencer raises arguments regarding the gag order's application to the public officials and to his family, the restriction on public and press access to the court file, and the due process rights of non-parties as to entry of the order without notice. However, Spencer clearly has standing to bring this petition requesting that this court vacate the gag order in his criminal case, and we will address Spencer's arguments to the extent necessary to resolve the issues raised in the petition. And I have somebody who I need to remove. Do not follow any links posted by these fucking chatbots. Oh, I hope you take a long walk on a short pier. Jesus Christ, I hate this. Do I have to do that? I've done it extensively on my Rumble account. It seems like Twitch is not moderating according to their own rules. Oh, I hate that. If there's one thing I wish these streaming platforms do, is to vigorously find these motherfuckers who create these bot accounts and sue them into oblivion. I'm almost at the point where I endorse using VPNs. I really do. But when these chatbots, there is clearly some companies out there that deserves to go to hell immediately, that lives on creating chatbots, spam bots, more correctly. I would not shed a tear if these people creating spam bots, buying chatbots, was removed from the human gene pool in any way, shape, or form. I hate it. I hate them with a passion. I cannot express with enough words how indifferent I would be if I saw them drowning. Every life has value. Doesn't mean I have to save them. They can bring it up on Judgment Day. Sorry for the rant. Let's continue with the important stuff. Why the fuck can't I remove that fucking comment? All right. Now let's continue. B. Freedom of speech. The First Amendment to the United States Constitution provides in part, Congress shall make no law abridging the freedom of speech. The First Amendment is made applicable to the states by the 14th Amendment. Similarly, Article 2, Section 6 of the Arkansas Constitution provides the free communication of thoughts and opinions is one of the inviolable rights of man, and all persons may freely write and publish their sentiments on all subjects. Spencer relies on both the United States Constitution and the Arkansas Constitution in arguing that the gag order in this case violates his and others' free speech rights. However, free speech rights are not absolute, and in rare cases must yield to the Sixth Amendment's guarantee of a fair trial by an impartial jury. Nebraska Press, blah, 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 discussing the Sixth Amendment. A gag order is defined as a, quote, judge's order directing parties, attorneys, witnesses, or journalists from refrain from publicly discussing the facts of a case, end quote. Black's Law Dictionary. Thus, a gag order is, by definition, a prior restraint on speech. As such, a prior restraint on speech bears a heavy presumption against its constitutional validity. In fact, the Supreme Court has recognized that criticism of the states lie at the very center of the First Amendment. This could include speech critical of judges, prosecutors, public defenders, and law enforcement. Gentile versus State Bar of Nevada. It would be difficult to single out any aspect of government or higher concern and importance to the people than the manner in which criminal trials are conducted. Quoting Richmond Newspapers Inc. versus Virginia, 1980. The Supreme Court of the United States has only directly addressed the constitutionality of gag orders as they apply to the press, not as to attorneys, parties, witnesses, or the public. Nor has the Supreme Court articulated a legal standard for when, if at all, such prior restraints would be permissible. In Nebraska Press, the court considered gag orders on the press and strongly disapproved of such prior restraints except in extraordinary circumstances. The court noted that pre-trial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of criminal case to an unfair trial. The court stated that it was required to determine whether the gravity of the evil discounted by its improbability justifies such invasions of free speech as is necessary to avoid the danger. To do so, the court examined the evidence before the trial judge when the order was entered to determine the nature of and extent of pre-trial news coverage, whether other measures would be likely to mitigate the effects of unrestrained pre-trial publicity, how effectively a restraining order would operate to prevent the threatened danger, and whether the precise terms of the restraining order were too broad or too vague. In Gentile versus State Bar of Nevada, the court considered the circumstances under which attorneys may be punished after speaking. The court upheld a prohibition on speech that presents a, quote, substantial likelihood of materially prejudicing an adjudicatory proceeding. Jesus Christ. English is not my first language. It's not even my second language. It's third or fourth language. My apologies for not pronouncing everything as it should. As provided for in Nevada's professional conduct rules, Gentile 501. Importantly, the Supreme Court held that the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press in Nebraska Press. Nebraska Press and Gentile provide guidance but do not answer the question whether or when gag orders may be placed on attorneys, parties, witnesses, or the public in pending cases. Here, the gag order was intended to address, quote, the need to protect the integrity of the jury pool, to ensure that, quote, all parties get a fair trial, end quote, in light of pre-trial publicity. When considering pre-trial publicity, a trial court has the difficult job of balancing constitutional interest while upholding its affirmative duty to protect the integrity of the criminal justice process. The Supreme Court made that clear in Shepard versus Maxwell, when it granted habeas relief to a petitioner who had been deprived a fair trial in a state murder conviction because of the trial judge's failure to protect him from, quote, massive pervasive and prejudicial publicity from the carnival atmosphere at the trial itself. The Shepherd Court noted that the trial court might well have prescribed extrajudicial statements by any lawyer, party, witness, or court official which divulged prejudicial matters. We recognize that Shepherd was an extreme case in which there was no doubt that the deluge of publicity reached at least some of the jury. The court ultimately concluded that Shepherd had not received a fair trial consistent with the due process clause of the 14th Amendment and reversed his conviction. While intense publicity can prejudice a trial, we note that an impartial jury need not be wholly unaware of information, including potentially prejudicial information outside of the record. We now turn to the arguments regarding which standard should apply to a prior restraint on speech in the context of this case. To justify a prior restraint on free speech, there must first be a factual showing of necessity. In other words, this court must determine whether the circuit court's order is justified by a sufficient risk of material prejudice to an ongoing judicial proceeding. This court has explained, the question becomes whether the justifications for restraining order are sufficient way to eclipse the substantial weight of the interest protected by the First Amendment, which dictate the heavy presumption against the constitutional validity of prior restraints. What then is the necessary showing? Spencer argues that a gag order is permissible only under the highest level of scrutiny, that is, if there is a serious and imminent threat to the administration of criminal justice. In contrast, the state relies on Gentile and argues in favor for a heightened standard that is less rigorous than strict scrutiny. In the absence of Supreme Court precedent, the federal circuits and the states have taken different approaches to gag orders. Some courts have adopted the clear and present danger or serious and imminent threat standard. See United States versus Ford, 1987, requiring a serious and imminent threat to restrain the speech of a criminal defendant. Levine versus United States District Court, requiring either a clear and present danger or a serious or imminent threat for a prior restraint on attorney speech. Another case, and the United States v. Trump, we hold that some aspects of the defendant's speech pose a significant and imminent risk to the fair and orderly adjudication of this criminal proceeding, which justified protective action by the district court. Briner versus Takao, and more. Jesus Christ. When determining which standard to apply, we must initially recognize whose speech is being restricted. We can identify three categories of persons potentially subject to gag orders: attorneys of record, non-attorney trial participants, such as criminal defendants, witnesses, and court staff, and the public at large, i.e., those who are not participating in a trial. Because the gag order ended here included members of all three categories, we review each to establish the appropriate standards. First, we address attorney speech. The Supreme Court has recognized that speech by an attorney is subject to greater regulation than speech by others. See Gentile. The court recognized that states have historically regulated admission to the bar and exercised authority to discipline attorneys. Attorneys have access to non-public information and are viewed as authoritative, both of which pose a greater potential risk to the fairness of a trial, and attorneys are officers of the court. For the same reasons, we find it appropriate to allow greater regulation of attorney speech in context of a criminal trial than would be permissible for the speech of non-attorney trial participant or members of the public. Thus, we hold that attorneys in Arkansas may be restrained from extrajudicial speech that poses a substantial likelihood of material prejudice to an ongoing criminal proceeding. This is consistent with attorneys' existing obligation under Rule 3.6 of the Arkansas Rules of Professional Conduct regarding trial publicity. Next, we consider the free speech of non-attorney trial participants. These persons are not subject to the same rules and restrictions as attorneys, but as participants in a trial, their speech has the potential to have greater impact than the speech of non-trial participants. See Shepherd. Neither prosecutors, counsel for the defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. And here is the footnote. We do not address gag order on the press in this opinion because the order before us does not impose restriction on the press. Thus, we conclude that free speech protections for non-attorney trial participants are greater than those of attorneys of record, but less of those of the public at large. Therefore, we hold that the speech of non-attorney trial participant may be restrained only to the extent that it poses a serious and imminent threat of material prejudice to an ongoing criminal proceeding. Finally, we address prior restraints on the public, whose speech is afforded the most protection in the context of gag orders. Restraining the speech of the public raises obvious issues regarding lack of due process. We cannot fathom why the circuit court believed it could prohibit the speech of any public official now holding office. In fact, it is difficult to foresee any circumstance in which a prior restraint on the speech of a member of the public, which would include a public official, could be constitutional. This here is the Arkansas Supreme Court saying to Judge Barbara Factwat that, how did this even enter your mind? Are you stupid? That is my interpretation, at least. Having established the legal standards to be applied, we turn to the additional findings a circuit court must make in every case to justify the entry of a gag order restricting the speech of any individual. First, the circuit court must determine whether alternative measures would protect the parties to a right to a fair trial. Here, Spencer suggests the extensive voir dire of prospective jurors using an expanded jury pool, giving cautionary instructions, changing venue, or postponing the trial or alternatives that should be considered before restraining speech. But the circuit court heard no evidence and made no findings in this regard. In addition, the circuit court must find that a gag order would be likely to accomplish the goal of preventing prejudice to the proceedings. Again, there was no such finding in this case. Finally, a gag order must be narrowly tailored to prohibit only what is necessary to protect the integrity of the ongoing judicial proceedings. In other words, the restrictions imposed must not be overly broad. Here, many of the prohibitions of speech listed in the gag order were overly broad. For example, prohibiting the public expression of an opinion as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendants by any public official is clearly overbroad. In sum, before entering a gag order, a circuit court must specifically find, based on evidence in the record, that 1. The prospectively limited speech would pose a sufficient threat of material prejudice to an ongoing criminal proceeding, depending on whether the limitation applies to attorneys of record, non-attorney trial participants, or members of the public. 2. After consideration of alternative, less restrictive measures, none would sufficiently protect the parties' right to a fair trial. 3. The prohibitions would be likely to prevent material prejudice to the proceedings. And 4. The prohibitions are narrowly tailored to prohibit only what is necessary to prevent material prejudice to the ongoing proceedings. This here, folks, 1, 2, 3, 4, is with this decision, it's case law. It's statute. This is something that has been, they have done it before, but this Judge Barbara shitface didn't care. So now they are making you have to do these 4 things. The language here is must, not it's your discretion if you want to. It is you have to. Not doing this is reversible error. That is what Arkansas Supreme Court says here. I think they are getting sick and tired of judges who goes outside of the law. C. Due process, vagueness, and overbreadth. Spencer also argues that the order is impermissibly vague and that it is impossible to know what is covered by some of its provisions. He stated that it is unclear, for example, whether statements on social media are restricted or must be removed, whether previously public filings now removed from public access may be shared, what, quote, for public dissemination means, and precisely who this gag order restrains. Spencer also argues that it's unclear exactly what exactly prohibition number 8 seeks to restrict. According to that provision, the named individuals cannot, quote, make any statements for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. The state, of course, maintains that the gag order is not unconstitutionally vague. The void for vagueness doctrine addresses at least two connected but discrete due process concerns. Regulated parties should know what is required of them so they may act accordingly, and precision and guidance are necessary so that those enforcing the law do not act in an arbitrary or discriminatory way. Stated differently, the prohibition against vague regulation of speech is based in part on the need to eliminate the impermissible risk of discriminatory enforcement. Vague prohibitions also create a chilling effect on speech because one does not know precisely what speech is prohibited. Here, we agree that the gag order is unconstitutionally vague and must be vacated. For example, who is included as part of Spencer's family? Does the order purport to restrain the speech of his second cousin and only that of his parents, spouse, or children? Due process requires more specificity. In his petition for writ of certiorari, Spencer does not develop his due process argument regarding overbreadth, but in briefing, he clarifies his assertion that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. It is unnecessary to address overbreadth as a due process violation in this case. Our decision is governed by the free speech and void for vagueness analysis above. D. Sealing the case. Finally, we address the circuit court's decision to seal the case. Spencer contends that the community has a right to know what its government does in public court proceedings. He cites Arkansas Code annotated section 1610-105, which provides the sittings of every court shall be public, and every person may freely attend the sittings of every court. Here, after the court's order was entered, the case filings were removed from public view. The inherent authority to seal parts of court files is tempered by the requirements that a request to seal part of a file must be particularized, that there must be some good cause for sealing part of a file, such as a trade secret, and that it should be in effect for only so long as is necessary to protect the specified interest. Not only are the written records inaccessible to the public, but also the briefs and statements from counsel at oral argument indicate that the Lonoke County Circuit Court's courtroom was at least partially closed to the public during Spencer's arraignment. Although it appears the Circuit Court intends to close further proceedings to the public, we caution the court from doing so without an evidentiary basis and adhere to the required constitutional analysis set out in Waller versus Georgia. Mitchell v. State, Schnarr v. State. The right to a public trial is one of the most important safeguards in the prosecution of persons accused of a crime. Conclusion. The Circuit Court's gag order is far too broad and too restricted of speech protected by the First Amendment and Article 2, Section 6 of the Arkansas Constitution. It is also impermissibly vague. Further, the order was entered without the requisite findings discussed above and wholly without a factual basis. Therefore, we hold that the Circuit Court's order constitutes a plain, manifest, clear, and gross abuse of discretion for which there is no other adequate remedy. Accordingly, we issue a writ certiorari and vacate the order. By this ruling, we do not foreclose the possibility that, after an evidentiary hearing, the Circuit Court may issue a subsequent gag order narrowly tailored to specific factual findings supported by the record. However, we emphasize that a gag order, quote, should be a last resort, not a first impulse. Petition for writ of certiorari granted, writ issued, Circuit Court's gag order vacated. Wood, Womack, Highland, and Bronny concur. Rhonda K. Wood, Justice concurring. Aaron Spencer argues that the judicial gag order violates both the United States Constitution and the Arkansas Constitution. He is correct that it violates the Arkansas Constitution. I write separately because, as a matter of the state primacy doctrine, I believe we should resolve this case under the Arkansas Constitution before resorting to application of the U.S. Constitution. The test adopted by the majority is appropriate to apply under the Arkansas Constitution as explained below. There are strong reasons to stick to state constitutional law in cases like this one. First, our role as stewards of the Arkansas Constitution is best honored by examining and interpreting it instead of the U.S. Constitution. There is underdevelopment of many state constitutional issues, and we do Arkansas a disservice by avoiding the Arkansas Constitution to focus on the federal one. When the state cede to the federal, it creates the possibility of states being a mere row of shadows. In fact, we encourage litigants to raise Arkansas constitutional arguments, and we should respond accordingly and address those raised arguments when appropriate. This is especially true in an area of law where the United States Supreme Court has yet to set a clear standard. We are addressing gag orders issued in Arkansas court, and our test should not be subject to the uncertainty of federal law when we can base it on state law grounds. Why not settle it for Arkansas now and interpret our Constitution as giving additional free speech protection to our citizens? I fully join the majority's test because it's supported under an originalist interpretation of the Arkansas Constitution. And then she goes on and on. So basically what this Supreme Court judge is saying, let's stick to what we have in and then concurring. So this is a unanimous decision to tell Judge Barbara Twatface, do better. Barbara Elmore, do better. Now, sadly, they did not vacate this judge, mainly because they haven't asked for it. The defense. I don't think so, at least. Let's see here. If they have. Let's see here. No, it doesn't look like they have asked the judge to remove herself from this case. So that's moot at the moment. I assume depending what will go on in the hearing in December, and then when the trial starts in January. So, okay, now we are more or less up to speed on this case. Now, there are many news articles out there. There are other content creators that cover this case. I urge you to find them watch their stuff, give a thumbs up and a comment, because the more people who cover this, the more people who get views, it will eventually, well, the chance at least of this case breaking through the glass ceiling, having it go at least somewhat viral, all it takes is a few viral posts from some content creators. Because when it does, the large accounts will follow. That is a universal truth. When we small content creators get something viral, the big ones will cover it. Now, hopefully, I will become one of these huge content creators. Now, at just under 20,000 subscribers, I'm still a small potato. Especially now, since the YouTube algorithm seems to have abandoned me. But over at Rumble, Animal Rampire says my second language is sarcasm and his third is swear words. Oh, that was so funny. Oh, let me put. I will do like this. Oh, eh. Virginia, if I remember correctly, a couple content creators were shadow banned. Yeah. This case does not bring the views it should. Even at, I believe who Bob over at Defense Diaries, they cover this case, and for them as well, compared to other things they publish, maximum a third of the views. It should be so much bigger. It should be this should be the case everybody talks about, but they don't. Melanie Lily is always demonetized for mentioning Aaron's name. Yeah, that, I mean, also when she does this, she has a fraction of the views she normally has. And it's the only way to overcome that is you guys at Rumble, now Twitch, YouTube, talk about it on X. Sooner or later, we will break through the glass ceiling. Now, the next court hearing in this is December 16th. But if any news show up, for instance, with Aaron Spencer's run for sheriff, I will cover that as well. There are more things in the docket. I mean, we have a motion in limine. This is, for this kind of big case, there are extremely low amount of entries in this docket. Extremely. It should be more, and I don't know why. I see that we have a troll here. The guy is a murderer. There's no difference between him and any other murderer. Oh, really? I suppose you don't have kids, and I suppose you don't have anything you care about. Would you protect your house or home or the basement where you reside? Mr. ELR? If you had a daughter, would you not protect her? Or are you simply here because you're a Michael Fosler fan and you, in actuality, if you have a daughter, you're probably on top of her right now, you fucking ass. Is that why you're protect? Are you here because you're a PDF? Elor? Is that why you're here? Is that why you're here? I think you are. I think that this cunt here, Elor, is simply here because he's a fan of Michael Fosler. That is what I think. And as every other fan of PDFs, fuck off. Bye-bye. All right. I've been doing this for years now, folks. Here's the basic rules of trolling. You have to be correct or funny. If you're neither, like Michael Fosler's fanboy Elor there, you fuck off. You're out of here. Boom. All right, folks. That is what I had for you today. And I chose this over reading the Delphi case today. I will find time for the Delphi case because we are entering the moment where the Frank's motion is being heard by Judge Gull on August 1st of 2024. And I need to build myself up for that. Because that, her actions, is probably the worst I have ever seen by any judge in any case I have followed here that I've read about. Her conduct is simply evil. But you will know when I go into it. I will publicly announce it. But folks, thank you for being here. You know what to do. Help all of us through the glass ceiling about the Aaron Spencer case. And thank you. Thank you for being here. Thank you for allowing me to do this. Hit the like button. Hit the subscribe button. Check if you're still subscribed, by the way. Sometimes YouTube removes subscribers. And I lost, since beginning of September, I am down about 200. So check, please. All right. From me and Mr. Jingles, who just screw off. I will see you in the next stream or video. Have a good one. See ya. Bye-bye.
Raven waves, brothers, axis high, shield strong. From the storm.